There's 7 grounds for divorce in Texas. However, we usually only realistically use about 3 of them. There's the no-fault grounds. So I guess it's the no-fault grounds and 6 grounds for divorce. And that's irreconcilable differences is what most people call that. And then we've got the 2 other more common ones, which are adultery and cruelty. And we usually use adultery when clearly there's been adultery, or cruelty can not just be cruelty in general. We often use those in sort of domestic violence cases and things like that. But honestly, pretty much every divorce can be done under no-fault grounds. We'll pull in the grounds when there's a reason to. Certain property division could be going to one person's favor more than the other person's favor. And I know I've had clients who come in for cultural reasons. They may want a grounds for divorce, adultery being the more common one. I actually had a client, she was from India, and she had married an American guy. And so one of the big parts of contention in that divorce was the fact that he had committed adultery, but he refused to admit to the adultery because he knew that in her culture, it was very important for her to have adultery as a reason, as a grounds for divorce, so that she could then remarry again in her culture. And so we had negotiated and made an offer, and he just was very stubborn about granting her that grounds for divorce. So we ended up having to go litigate that, and we won, which was great. It was really fun showing the pictures that, about his advertisements on Craigslist for fun stuff, and some of the pictures that ensued that he didn't realize, I guess, at negotiation time that we had. So we ended up getting her grounds for adultery and some extras. And so, yes, once in a while, using the grounds for divorce can be great, but usually there has to be a strategy behind them. Otherwise, you can pretty much do any divorce under no-fault grounds. So I get a lot of questions, how do we divide our assets? And in Texas, you divide assets into either community property or separate property, and then depending on how they're characterized will depend on how we get things divided. So in Texas, you cannot divide separate property, but there is a burden of proof. You have to show and demonstrate that something is your separate property. And separate property generally is going to be what you brought into the marriage. So anything before marriage is going to be your separate property. And then you can have gifts and inheritance, and those are going to be separate property at any point. So you could be married and get a gift or inheritance, and that'll still be separate property. There is an assumption, however, or a presumption under the law that everything is going to be community property, so everything is divisible. So if you do own something that is separate property, it is your burden to prove that it is separate property. Now, assuming you get the separate property, you carve that out and set that aside, we don't divide it. That's yours or his to keep. The community property is what we focus on, and the community property is generally divided in a fair and just manner, right? There is no exact way that it's divided in Texas. I think a lot of people have this assumption that's going to be divided 50-50, and certainly that's kind of a good place to start, but there may be reasons why you would want to divide it disproportionately. Say one person contributed more to the household, and so they didn't have a chance to work while the other person got to advance their career. That may be a reason why that non-working spouse should be entitled to a bigger percentage than 50%. Perhaps there was adultery, but usually it's not adultery in and of itself that would grant the disproportionate share. You usually have to prove something like they spent a lot of money on a paramour, such as I've had instances where we found husbands who had a girlfriend and they paid for their rent for an apartment and helped furnish their apartment. So, spending tens of thousands of dollars on this person. So obviously that would be something that would be contributed back to the community property and then divided up between the spouses. Another tip that we have is generally the bigger the estate, the closer to 50-50 the courts will generally kind of divide it. And so that's another, kind of way that we look at it. But there is actually a lot of different reasons why you might divide something disproportionately, and it's really kind of a case-by-case instance. So we use the factors that are in our family code, but generally when we come talk to a client, we will ask them a bunch of questions and then we'll kind of build a strategy around that. So I love the alimony question. People call it alimony, but we have 2 things that fit under alimony. One is the statutory spousal maintenance. That is, I think, what a lot of people look up online is Chapter 8 of our family code. And that is where you have like this 10-year minimum. You have to be married at least 10 years. And then you can get, like, there's a whole formula on how much you can get depending on the length of marriage. And it's capped. And that is spousal maintenance. That is separate from contractual alimony, which I think a lot of people don't know about, even though it's called alimony. Contractual alimony is what you can actually negotiate, and there are no requirements. You can be married for a day, and if you have some sort of leverage during the negotiations, you can get contractual alimony. And that's really just a negotiated amount of alimony with no caps on it or anything like that. So that's the first thing we do when clients come talk to us, is we help them distinguish between the two. And there are pros and cons to each of them, right? So contractual alimony is you're locked into a contract and it can't be modified, but you also can't collect it the same. If your spouse or your ex-spouse fails to pay it, then it's a little bit different on the collection side. Versus spousal maintenance, which can be modified because it's a court order. And so it can come in later if, say, your spouse can no longer pay it, or, you know, there's some reason that the alimony has, the spousal maintenance has to change. And so it can be modified by the court. But the enforcement is also a little bit different because it's a court order that you'd be enforcing, and so your remedies may be a little bit different for that too. So again, when we're talking to clients about alimony, we tell them the two different forms that it can take, and then sort of go through the pros and cons and figure out a custom plan for each of them to see which is the best fit. So that answers the first part of that. When talking about alimony, it's important to know the distinction between the two, but also what are the chances of getting alimony? I think that's a big part of this also. A lot of clients will look it up, they'll Google it, and they'll read the way it's structured in the family code, and they see it as an entitlement. It's not really an entitlement. It is more of an aid to help someone get back on their feet. So just because you've been married for 10 years does not automatically grant you the spousal maintenance. You still have to prove a need for the spousal maintenance and an ability for the other person to pay. And so then the question becomes, well, do you really need the spousal maintenance? A lot of stay-at-home moms feel like they would be entitled to it because they've been stay at home. But actually, a lot of the courts discourage that. They want them to go out into the workforce and become self-sufficient. And so that's a conversation sometimes we have to have with our clients. And fortunately, at our firm, we have resources to help our clients with that. So we have people like career counselors and career advisors. We have videos on how to set up your LinkedIn profile and resume building and things like that to help stay-at-home moms who have been out of the workforce to get back on their feet. But that doesn't mean that they can't get interim temporary spousal support. So while you're processing things and getting back on your feet, there is an opportunity for you to get temporary support to help you do that. If you need to go back to school and get an education to get you that degree, to get you that job, let your lawyer know so that we can then try to negotiate that or get that from a court order, and that will increase your likelihood of getting that temporary spousal support. And then once the divorce is final, you may have an opportunity, there may be a chance for you to get the permanent spousal support as well. I say permanent, there are caps on it, but it's not as likely. I think the expectation of most courts is that neither party should be dealing with the spousal support and either giving it or receiving it. It causes a lot of practical problems as well, in that we've had clients that will get the spousal maintenance, they'll get the alimony, and then the other person actually fails to pay it on time. And it's really tough when you are expecting that alimony to come in and you have your bills all tracked. I'm going to pay the bills on the 1st and 15th of the month, and then that spousal maintenance doesn't come in, and all of a sudden your whole budget kind of goes. And so I'd like to tell clients that scenario so that they understand. I think a better approach may be to get a disproportionate share where you get more of the community estate. That way you have control over it, and then you can invest it. You can put into annuities that pay out. You can do whatever you want with it, and you're in control of that money rather than letting your spouse continue, or your ex-spouse continue to control you post-marriage through alimony. Basics of custody. What are the basics of custody? So I think custody is not a legal term that we use in Texas. I think that's more of a layman's term that we hear a lot. So when people ask me about custody, I have to tell them it's kind of two things. Really, kids stuff I put into three categories. You've got the conservatorship, which are the rights and duties to your child. And then you've got possession and access, which is visitations, the time that you spend with your child. And then you've got the financial component, which is like child support. And so when you're talking about custody, I think most people are thinking about those first two, about the time that you spend with the child and your rights and duties to the child. And so, there are presumptions in Texas where the parties are going to be joint managing conservators. So you guys are going to have like this joint custody, but the time that you spend with the child may be different. And so the rights and duties are pretty standard for most parents. Unless you've done something really atrocious, you're both going to have the same rights and duties to your child, the rights to care for them, the right to attend school functions, to make medical decisions, to make legal decisions. All that stuff is going to be joint, usually by agreement or independently, that each of you can kind of have those independent rights when you have them. Sometimes we negotiate the rights, or they're ordered in a way that only one parent gets to make those decisions. And in those situations, maybe one parent is considered more primary. But again, that's very fact specific based on the types of cases, based on your case and your individual situation. And then the time spent with the child, that could also mean, do you have primary custody? Do I spend more time with the child? So visitation agreements, parenting plans, we talk about all that with our clients when coming up with custody. If you have any questions about any of the topics that we've discussed, please feel free to reach out to us. Visit our website at www.familylawdfw.com or Google us at Alexandra Geczi Family Law.